This is industry standard isn't going to cut it anymore. I am directly speaking to music distributors. It is my belief that music distributors are engaging in unfair business practices. Right now, there is no oversight. Quite frankly, a whole lot of you are like, I just want to get off of music platforms altogether. This is escalating, and will continue to escalate beyond this. Dear music distributors, this is my open letter to music distributors. On this channel over the last couple of years, we have really grown as a music business community. We do music business education here. And part of what we do is we look at the terms of service that are on the websites for these music distributors, right? So for context, the terms of service, this is the agreement that users sign and agree to when using a distributor's services. And on the channel, we've looked at all the major distributors such as TuneCore, DistroKid, Symphonic, CD Baby, and the list goes on, but those are definitely some of the biggest. Having now grown to like, what are we at, 120,000 subscribers? It's still a very, very small portion of the millions of music creators who have signed these contracts with music distributors. The reason why I care about this so much and why I'm directly speaking to music distributors is because for the millions of creators that you represent, you have an obligation. You have a duty in a very different way because music creators do not have an option to not use you. In order for music creators to get their music on music platforms like Spotify and Amazon Music, they have to go through a music distributor. So that means now you have an obligation that maybe otherwise you wouldn't have had, but you do. So as we've been reviewing the terms of service, we go, oh boy, what we've identified is that there seems to be these incredibly unfair business practices. And some of the terms that we've looked at have been just downright shocking. And in my professional opinion, unlawful. And in certain cases, we reach out directly to music distributors. And a part of it is because I'm a real lawyer and I run and have a law firm. And so we are representing creatives when certain problems come up. And so we reach out and we try to problem solve. And as part of kind of what we try to accomplish is to say, well, if we feel that there are unlawful terms, if there is a one-sided, unfair terms of service contract, well, perhaps by being transparent and asking that you make these updates to your terms of service, that you will just voluntarily do so. And the reason why I focus on that you voluntarily do so is because right now there is no oversight for music distributors. And as middlemen for creators, meaning they have to go through you, they have to use you. You are similar to performance rights organizations. So here in the United States, right, we have the three majors, ASCAP, CSAC, BMI, there's 6 total. And of 2 of them, there are actually government-imposed consent decrees. And these were put into place by the Department of Justice. And it was because the Department of Justice was like, we need to make sure to prevent an abuse of power. When there are companies that start to engage in monopoly-like behavior, there has to be something that happens. There has to be something that gives. And my goal with, music distributors is that perhaps if we just openly address this issue, that you'll voluntarily come to the table because this is escalating. And will continue to escalate beyond this. But you know what? I go, let's see if we can actually do something and make meaningful change. So while there isn't any safeguards in place right now as it relates to music distributors nonetheless control a massive portion of royalty collection and distribution for music creators. And so I believe that, the terms of service that I have personally reviewed, and I have done this for over 10 years, reviewing terms of services for businesses. So I'm very well versed on what these should look like. And what I can say is that the terms of service that we've been reviewing as a music business community are inherently unfair. They're one-sided and they've become really exploitative. I want to be very specific about this on my kind of top list of the issues that we've identified across the board. Number 1, there's this unilateral withholding of royalties that music distributors write into their terms of service. What do I mean by this? Well, it says we essentially are the bank. We take artists' music. In order to put it on music platforms, we then send it to the music platforms. Music platforms generate royalties, streaming royalties, send it back to the music distributor. Distributor then pays the artist. So the pass-through of royalties is a music distributor. And what we have read is that there is a right amongst all the distributors that they put into their contract that says, we reserve the right to withhold your royalties if we so choose. And in some instances, they might give you a little breakdown. And you might say, well, in the instance, there's a claim, there's alleged copyright infringement, there's alleged trademark infringement. We think that maybe there was streaming manipulation. So in some instances, you actually will give a breakdown and be like, well, if we think that you did something naughty in violation of our terms of service, we reserve the right for all those reasons, but also for no reason. We reserve the right as the boss of our own company to withhold your royalties. We will unilaterally, without your input, make this decision and we will take your royalties. So again, as a practitioner, when I have someone who is generating revenue, they make money from their music. That is their property, not yours. And music distributors hide behind this language and to say, well, because it's in our contract that you signed by clicking the I agree button. Did anyone actually read this contract? Well, I did. And so you stand behind that language and you say, no, that's good enough. So therefore, we're going to withhold the royalties if we so choose. And again, being on the ground floor, actually representing artists where we have someone who, let's say, had about $60,000 in royalties, $100,000 in royalties, and they ran into some kind of issue, whatever it is. And then there's a breakdown of communication because all of a sudden now we have an issue of just general customer support. And so there's a breakdown. The artist cannot get to their royalties. They get locked out of their account. They can't get into touch with you because you have poor customer service. And then because you have this in your contract, somehow this should legally justify you taking royalties and property that belongs to someone else and you keep it for yourself. And as we even found in one of the terms of service for one of the majors, that you not only could keep it for yourself, but you could actually pay it to a third party without the artist's consent. That's number one. Number two has to do with, well, at what point are we kind of starting to think that this has become monopolistic behavior? So we're looking at the royalties that have been generated by artists, it's their property, and the withholding of the royalties without legal justification, in my opinion, constitutes a legal theory called conversion. You are taking something that does not belong to you. But artists do not have another option. That is the difference here between you just being another company and these just happen to be your terms of service. Take it or leave it. These are not negotiable for creatives. And then the most amazing thing about this is actually industry standard. And the biggest companies that serve millions of primarily independent artists and independent record labels. And again, one of the justifications is this is just industry standard. This is how it is done by everybody. And that's not going to cut it. So at what point do we say, well, this is unjust enrichment. You're benefiting to the detriment of creatives. This is becoming a monopoly. Another major concern that I've seen in at least one of the terms of service for one of the major music distributors is that there is language literally saying, we as the company are going to hold your royalties and we as the company are going to put it in an interest-bearing account, meaning we are going to make money off of your money and you, creative, irrevocably assign those earnings to us as the company. I'm struggling with this for a company that really has a relationship that is tantamount to being a fiduciary, meaning you are entrusted with the collection and payment of someone else's royalties. And in most instances, when we have that kind of a relationship, we go, well, it's a fiduciary relationship. You have a higher obligation, a higher level of commitment that is required. And so when I see that there is language where literally this is a business model for you to make money off of other artists, but also it's advantageous to you that that money sit in your account as long as possible. When did it become appropriate or okay for a company that represents artists that collects royalties to do something like this? Now, also on the list, well, we look at the boilerplate language in your contracts. So meaning that you have language stating that creatives basically have no real legal recourse against you. We look at provisions such as limitation of liability. And so you say, well, by using the service and clicking I agree, you agree that in most instances, the liability cap that we as the distributors can possibly have is no more than $100. You make it so it is practically impossible for a creative to ever get any meaningful legal recourse. There is no accountability. Also, if there's some kind of mistake, because it says it in your contract. We make no warranties. We make no representations. And even if there are mistakes made, you know what? You're going to indemnify us. The landscape of music distributors generally, it's become very, very exploitative. And music distributors seem to be hiding behind this unfair one-sided language. And again, I can say that because I have done this for over 10 years and I talk with you music distributors almost every single day. And the times you come back and you tell us to take a hike because you point to the terms of service and you go, well, they agreed to it. They could not agree to it. So what are we asking for today? This is industry standard isn't going to cut it anymore. And we're asking for music distributors to voluntarily update their terms of service based on the following. Number one, we're asking for clear, fair, and transparent royalty withholding policies. We need to understand to the extent that you are going to withhold royalties because maybe there's a claim of some kind. Well, if that's the case, you have to be empowered as a company representing hundreds of thousands, if not millions of artists to be able to actually and timely work through any kind of claim that might arise. You cannot say, we will handle your money, but if there's a problem, you know what, we're going to put a pause on everything. We might just go ahead and just take the royalties because we're going to say, you know what, we think that you may have violated some kind of term. We're not going to look into it. We're not going to provide evidence of anything. We're not going to exercise good customer service communication. These things do not connect, and these things ultimately cause harm, and they are causing harm to music creatives. Two, we want a standardized and fair dispute resolution process. Sorry, if someone has to come and hire me to deal with an issue because you have ceased communication, and then we ask, well, what's your evidence? If you're going to withhold someone else's royalties and be unjustly enriched in doing so, and you refuse to provide any evidence whatsoever to support that there was an alleged violation, that there's any validity to a third party just filing a claim, just saying that there was something, but no one ever proves anything. If you can't prove it, you don't get to keep the royalties. We also, number three, want a limitation on the retention of artist funds and interest. Okay, if you're one of these companies that is making money by having other artists' money sitting in your account, sorry, I don't think it should be permitted. And I think that you should have any interest that is made to then be redistributed to that artist's account, or just don't do it. Number four, a more reasonable and equitable liability limitation. To the extent you say that if there is an actual harm caused to a creative using your platform, you will only be accountable up to $100. This is an example of when I say we have an agreement that is one-sided and inherently unfair, making it practically impossible for any creative using your platform to ever get a meaningful remedy. This is really as simple as these companies recognizing the problem here, recognizing the elevated position that they have in this specific situation, and doing something about it. There was one smaller music distributor who came back and said, you know what? Appreciate you pointing out these issues. We're going back to the drawing board. We're going to take a look at the terms of service and we're going to revise them. They haven't done it yet, but they did in fact say that. They did in fact make that commitment. And what I've said to everyone that I have spoken with about this is like, oh, I'm just waiting for someone to step up and be the hero. I'm waiting for someone to be like, you know what? Yeah, we're a business. Yeah, we're, about making money. Fine. I don't have a problem with that. But it becomes a problem when at scale that there truly are just millions and millions of creatives who are disadvantaged in this position. And now, quite frankly, a whole lot of you are like, you know what? I just want to get off of music platforms altogether because it's too hard. And this is damaging, not just from I lost my royalties, my music got taken down, and the literal problems that I'm fighting for you guys for every single day, but it's just one more thing that you have to deal with when, I don't know, I can speak for myself as a creative. I kind of just want to make my song today. And I have to be over here fighting these music distributors. But I'm not the kind of person to back down. I just can sympathize how much as a creative, truly, this is why I do everything that I do. Literally why I started a law firm. I didn't need the money. I just wanted to help. It's why I started my YouTube channel. Didn't need it for any other reason than I just wanted to help. And that's why I'm doing this today. It is my belief that music distributors are engaging in unfair business practices, and those practices mirror monopolistic behavior. So we're asking for fair, transparent, legally compliant terms of service. And I am specifically asking my community, my music business community, to drop a comment down below on this video. I want you to tag your music distributor, and I want you to ask your music distributor to revise their terms of service. I'm Top Music Attorney. I'll see you guys on the next one.